Global Investor Forum. Hi, my name is Monica Young. I'm the host of the Global Real Estate Investor Club, and I'm the broker of Just Global Inc. Welcome to our Saturday event. Today, I'm going to give you a market update in a few minutes, and then going to be followed by our featured speaker, Mr. David Bonaccorsi. I'm sure that you're very, very much looking forward to hear what he has to share about the SB 91 on rental assistance for both the landlord as well as tenants. So as a group, we are a licensed real estate broker, and we've been doing a lot of real estate transactions. As you might have heard, the market is very, very active, especially since the 2021, we see more activity than before. So let's start with the first slide. As you can see, the market has become very, very much active in terms of existing home sales. Right now, year to date, compared to last year, it's as high as 23.6 year to date for just 2021. But year to year, you can still see a 16.1% increase. And in terms of existing home price, it has almost like 26.5% change. And you can see that this particular market is definitely, very much in at the seller's market. The buyer has to overbid, and most of the time, we can see that if a property is on the market, they go pending within about 10 days, and the sales price overbid by 104%. Next. So we're going to talk about Santa Clara County first. Santa Clara County is South Bay. That we have an office here in Sunnyvale, and also we've been covering both Santa Clara County, Alameda, as well as San Mateo. And you can see that there's a 14.3% change year to year. It's a 1.6 million medium home price, and the sales is really tremendously active. You can see it's 44.3% over the previous year. However, due to the pandemic, the inventory is 21.4% less than the year before. And most of the time, if we have listing, we can see that it could go pending just within a week on the market. And the bidding price average is 108%. But we've been bidding on property. We just got actually a bid accepted, and that is in Sunnyvale. It was listed for $2.4 million for 1,700 square feet. And the final bid, 15 offers, ended up, our buyers like it so much, we actually pay over $600,000 over. So the market is pretty much tremendously active. San Mateo County, the Mid-Peninsula, as traditionally is more expensive. The median home price has become like 1.99 million, and is 13.4% change year to year. And also, active listing wise, it has dropped because the inventory is so tight. Like many buyers were anxious to get a home because of the low interest rate and because of the concern about inflation. As you know, like you might have heard, the lumber price and all the sales materials have been going up in price. So people are anxious to get a home into contract. And currently, the first-time home buyer made up about 52.8% of the market. Again, the median home price is slightly over a week, and sales price is 105.2%. Next. Alameda County. So you can see that is a major increase year to year. So it's 19.8% higher in median price than last year, and up to 1.16 million. In fact, we have many sellers who actually come to us and say, hey, we really want to sell because we think the market is a seller's market. It's a good time to sell. So if you're thinking about selling, please reach out to us and we can give you some more information about the latest market trend, and also, how much your home would be worth in order to sell. So you can see that in order to buy a home in the East Bay, Alameda, you have to pay 112.6%, pretty much, quite a bit over the asking. And at the same time, the inventory is very tight. I'd like to share with you what we have coming up. So we do have some listings that you can preview, or you can come to us if you want to know about this listing off market. So this is an active listing, just came on market a few days ago. So in Cupertino, it's about 1353 square feet in a decent sized lot, and it's a very well priced because it does have like a middle school as well as the Lynbrook High School. So it's moving ready. Talk to us if you're interested. It is in 95129, San Jose area with Cupertino School. Next. So this one is going to come up end of next week, is in Fremont. It would be really good for the first-time home buyer. It's 3-bedroom, 1.5 bath townhome, very close and convenient to 880, and is decent school. And the price, I think, would be about low 600, and would be ready by coming week. Next. So this is actually very nice property, very nice, quiet, and very bright and light. And it has a view of golf course, 2-bedroom, and also with attached garage. And the price is going to be about mid-800s, and will be ready in 2 weeks. Is being staged and also being photographed. So basically, it's not San Jose, very convenient. Next. So this is newer townhome in Hayward, and very convenient, very close to the bridge, and also, you know, if you want to commute by BART, is minutes away, and a 3-bedroom, 2.5 bath, and the sales price is going to be fixed. So it's about 8 years new. So this also, I think, is going to be a pretty hot property because very convenient and also well conditioned. Next. So this is a home in Evergreen, is still being worked on. So it would be coming soon. The price would be, I think, between like 1.15 to 1.2 million with good schools. So if you're interested in looking at Evergreen, please talk to us. Next. So this one is in Valley City. It can be used as a 2-unit because it's a downstairs unit that has been rented out before, but now the tenant has just moved out. And so it could be used for maybe one extended family. And the price would be at about like $1 million. It would be coming to the market soon. Next. So we actually have this property went pending a day ago, and we have 18 offers, and the price is 27% over that. So like I mentioned, right now with the current market, a lot of overbidding. You know, we just got a Pleasanton property accepted, and they listed at $1 million. They had 28 offers. It's so competitive. We got the bid, you know, with a lot of work, and we actually have 27% over that on that Pleasanton property. As we can see, a lot of people moving to Danville, Pleasanton, and San Ramon. So East Bay is highly seeked. So if you want to talk about the market, let us know. Okay. So pretty much next. If you want to talk to us about real estate, you can reach out to me or Carl. You know, we run a small boutique brokerage, but we've been working very hard. Like so far, like this year, so we have more than like 15 listing and purchase and more coming in. So it's been a very, very active market, and we've been having a lot of clients to get this accepted and also have sellers to get very good price. Okay, so next one, we're going to have our feature presentation. So thank you for David for coming back to speak to us about the latest SB 91 on the landlord assistance and the tenant rent deferral moratorium update. And Mr. Bonaccorsi is a partner of the law firm Bernard, Balgley, and Bonaccorsi, and he has been practicing law since 1987. And David has served as a former Fremont Council member on the Fremont City for 2017 and 18, and also he's been on the Planning Commission and twice elected as the Planning Commission chair, and very, very experienced. And all the time, you know, he has addressed issues of rent stabilization and reform, and also review the rent review ordinance. So, David, I'm going to have you have the floor. Thank you.
Thank you very much. And Welcome everyone this morning. Thank you for coming out at 10 o'clock in the morning. And thank you Global Real Estate Investors Club for hosting this event. Yes, my name is David Bonaccorsi, and we're going to be going over some of the latest updates, but I want to take you a little bit back in time since we've had the pandemic, just to show where we're at, because some of the things that happened as early as September of last year apply to today's laws. And just as a kind of as a general disclaimer, I am an attorney at law. I am not providing legal advice directly to anybody here as a client. If you want to call me or any other attorney, please do so afterwards. This is meant as a general presentational evaluation of the laws, and we're also going to be providing the PowerPoint afterwards and some of the forums as a resource for you. So I hope it is a good resource. Carl, if we could proceed with the first slide. Let's take you back to March of last year when we had a declaration of emergency due to the pandemic. Historically, landlord-tenant law has been really pretty much about how you evict a tenant, you know, how a landlord retakes possession, has been historically exclusively a statewide issue. There have been abilities of cities to regulate rent control and maybe add just cause eviction here and there. But I would say it's been dominated by state law. That all changed with the oncoming pandemic. And the reason it changed, and this is something that's going to inform our discussion throughout, is that there's been an ongoing public health priority to keep people in place. We don't want tenants moving about, getting dislocated, mass evictions, because of the concern, the legitimate concern for community spread of COVID. And how that plays out as you see these new laws and regulations is, yes, if as between the landlord and a tenant, it does feel as if the tenants have the upper hand, and that's the consequence of trying to limit evictions to situations that are more dire, and if it's just about rent, to really regulate and defer landlords being able to be made whole. So in about March of last year, the governor started authorizing local control to allow cities and counties to be able to regulate moratoriums on evictions, and the counties and cities exercise control. And we'll talk about the California Judicial Commission briefly, as it froze everything for about 6 months. March 4th, COVID-19 state of emergency was proclaimed by the governor. We're still in a state of emergency. March 16th, he issued a very important executive order, N-2820, which allowed the cities and counties to regulate in the area of evictions. The governor also allowed cities and counties to enact commercial moratoriums. My focus today is going to be really on the residential. I can talk conceptually about the commercial moratoriums. There, it was really trying to keep small businesses in place. And he's allowed cities and counties to continue to regulate in that area all the way through June 30th, 2021. He's been extending that for now a year and a half. Next slide, please. On September 1st, from early April to September 1st, the California Judicial Commission, which is headed by the Chief Justice of the Supreme Court, basically put locked the doors of the court to anybody trying to evict anybody. So that became a statewide rule. The Chief Justice lifted it at the end of August and said, legislature, you have to step in and come up with rules maybe that are more uniform. And then we had all these patchwork laws that have been out there. So on September 1st, the COVID-19 Tenant Relief Act of 2020 passed, AB 3088. So it's called CITRA, C-T-R-A, just as the California Judicial Council Commission eviction ban expired. This has become the law unless a county had enacted or city, unless a county or city had enacted an ordinance before August 19th. And now I know most of you are probably in Santa Clara County. Unfortunately, or fortunately, depending upon your perspective, Santa Clara County had renewed its moratorium on August 25th because it was so recent, it was overtaken or superseded is the word that we use by AB 3088 or Citra. Alameda County's ordinance, however, still remains in place. It's grandfathered in, and we follow in Alameda County rules rather than the state rules because it was enacted before August 19th of 2020. Next slide. I don't know how many of you are from Alameda County, but I will just briefly say that there's a rent deferral for 12 months. It's a rolling rent deferral, but Citra did step in and say you can't keep deferring rent for 12 months indefinitely. And it put a cap that as of March 1st, 2021, you can't defer rent past March 1st, 2022. April, May, June, in theory, tenants in Alameda County have to pay rent, but under Alameda County, there is still a rent ban or a rent eviction ban in place until 60 days after the county declares there's no longer a health emergency. So clearly there's still a county health emergency, statewide emergency. When is that going to be lifted? Who knows? I'm not in the prediction business, but maybe after the children are vaccinated, if there's a children's vaccine in September and October, and we get down to 0 new cases, maybe by the fall of next year, you may be seeing these emergency bans lift, and then the courthouses will begin to open up again, at least in Alameda County, to evictions for non-payment of rent. Next slide. Now I'm going to talk about Citra because that applies in Santa Clara County and most other places in the state. First of all, it does not apply to commercial tenants. As I mentioned before, the state has allowed counties and cities to have their own moratoriums. Those are the ones that are in effect. So if you've got a commercial tenant, or if you're a commercial tenant yourself, you're going to want to know if there's something in place where you are. Citra only deals with residential properties. March 1st to August 31st, 2020. It sets up these 6-month periods under Citra, March 1st through August 31st, 2020. A tenant who provided a declaration of distress, of financial distress, or a high income tenant meeting certain requirements and verification cannot be evicted for rent for non-payment. So if they didn't pay you rent during that 6 months, that rent you'll never be able to utilize in an unlawful detainer case as a basis for evicting a tenant. There's other things you can do in trying to recover it, but this was considered the protected period and remains the protected period during the initial onset of the pandemic to freeze tenants in place. And even if they didn't pay rent, that could never be used by the landlord to evict. High income residents are defined as household income on 130% of area median income, and they must also provide proof of income. So if you have a tenant that works in the high-tech industry and is driving with a Ferrari into their carport, you may be suspicious. They say, well, they can't pay rent. Well, they have to prove that they lost their jobs or some financial distress. And I'm going to show you after this, Mr. Yun, if after we're done with this slide, then I think we're going to have a chart that I can show you. You were supposed to, as of this date, provide an informational notice and to explain that unpaid rent was protected. And then there was a second 6-month period that went from September 1st, and here's a typo, it should be January 31st, 2021. The landlord cannot evict tenants for rent non-payment as long as, again, the tenant in response to a notice to evict or otherwise voluntarily provides a declaration of financial distress. Here, this period is called the transitional period. The idea was the legislature was trying to wean tenants and landlords off this limited eviction process, this limited extension of the moratorium. And as long as the tenant paid 25% of the rent, then they cannot be evicted. And 25% of the rent met at any point in this period between September 1st of 2020 and January 31st of 2021. So the example I use, let's say it's 6 months worth of rent. Somebody has $2,000 a month of rent. They don't have to pay 25% of 2,000 in September or 25% of 2,000 in October. They should, but in theory, as of January 30th, they could have paid you a check for $3,000, which is 25% of 12,000. So 2 times 6 is 12. 25% of that is 3. They could have handed you a check on $3,000 on January 30th, and at that point, they would not be eligible for eviction. You could not evict them for non-payment. Carl, do you have the slide for the high income earners? Are you able to integrate that?
Which one?
The chart that shows that you provided me, the CAA chart on high income earners. It goes what is 103% of income in Alameda County. If not, I can read it.
Oh,
Just
okay.
to give you an idea, high income earners are in Alameda County is anybody that earns 108,485. So they have to say, hey, look, before this, I was earning 110,000 a year for one, and if it's a family of 4, it's 154,000. Santa Clara County, by contrast, where most of you are, is 130% of income for one person is 128,830. So if they're above that amount per year, they have to provide you additional documentation, tax returns, W-2s, pay stubs, to show that they really have financial distress. They have a little bit of a higher burden to be able to not have to pay rent. And I should add that any information that you get from Tenant is really confidential. You can't use it for future rent increases or anything like that. It really is a limited exception to the financial right of privacy most tenants should enjoy, just for that limited purpose of seeing whether they qualify for the rent relief under Citra. Next slide, please. Hello?
Hello. Oh, did you see
Next
it?
slide. Okay, there we go. I see it. There's something called AB 1482 that passed in 2020. I gave right before the pandemic. There was a law that came into effect called AB 1482, and AB 1482 regulates statewide what's called just cause evictions. If you have a property that's more than 15 years old and you're a corporate landowner, then your tenant has the right to anticipate just cause eviction. You can no longer send out a 60-day notice or a 30-day notice if they live there less than a year and say, hey, that's it, you're gone. You have to have specified reasons to evict. Now, there's some exceptions that were built into the law that if you're a mom and pop operation and you're not a corporation, or you have just a family LLC with no corporate members, you can exempt yourself, but you have to submit an exemption with it in the summer of last year in order to exempt, otherwise it applies. Well, if you had property less than 15 years or you were exempted, then AB 1482 doesn't apply. Well, the Citra, at least temporarily, expands AB 1482 for just cause across the board for anybody that's a tenant. And one of the rules here is that one of the exceptions for just cause was if you were doing a substantial remodel. Well, under the law, it was if you had to pull a permit to do a significant kitchen remodel and you wanted to evict the tenant and have a new tenant come in, that's all you needed to show. Now it's limited to basically health and safety issues. If there's some health hazard that the city or a county has indicated you need to take care of, that's different. So that's essentially eliminated that exception. Back under Citra, the courts were open for just cause eviction other than rent non-payment. And they were anticipating they were going to open everything up by February 21st for all cases when Citra ended on January 31st. But now let's go to the next slide, please. That's no longer true. Under SB 91, that was enacted January 29th, right before Citra expired on the 31st. And they extended AB 3088 or Citra through June 30th, 2021. So we talked about that first 6-month period from March through August 31st, 2020 as the protected period. That remains protected, as in that if a tenant doesn't pay rent during that period of time, you cannot use that as a basis for eviction. Now, the transitional period that started in September of 2020 now goes all the way through June 30th, 2021. Remember my example earlier of the tenant that doesn't pay $2,000 per month and pays a fat check on January 31st or January 30th of 3,000 out of 12,000. Well, you now have basically another another 6 months or another 5 months. So that check could be 25% of all the rent due paid to you on June 29th or June 30th from September 1st as one lump sum check. And if they give it to you in that time, you cannot evict. But there is a process that we're going to talk about how you get a tenant to make sure that they are subject to CITRA. It extends the moratorium, and there's going to be new rental assistance programs I'm going to talk to you about in the other slides. There are now new tenant protections. There's now a mandatory new landlord notice required by February 28th. And this is terrible because I gave one of my first lectures on CITRA and SB 91 in early March. And of course, it's after February 28th. And if you don't give a notice of this new law, if to a tenant's not paying rent, in theory, a judge might say, well, you didn't give that notice and therefore your eviction doesn't work. So we'll have to see how that plays out. But right now there's a moratorium that extends until July 1st that I'll mention again. So we haven't seen how the courts are going to handle evictions under qualifying tenants that are submit declarations of financial hardship. Next slide, please. The extensions, as I said, extend from March 1st all the way to June 30th. There's now a new 15-day notice required for non-payment with enclosed declaration of hardship. Again, there's two kinds: the tenant that is that earns less than 100,000, or the high-income tenant that has to prove that they are subject to protection. Again, if they give you a timely return of their declaration of hardship, you cannot evict them. And 15 days is not just 15 days on the calendar. You cannot count the first day, and you cannot count holidays or legal court holidays or weekends. And if the 15th day falls on a Saturday, then they have until the following Monday to pay. So you can have a 15-day notice that may, in practice, give the tenant as many as 20, 25 days before they have to return it in a timely fashion. And the 25% rent payment, as long as the tenant pays 25% of the rent that's due, either per month or however the tenant wants to budget it, or as a lump sum at the end of that period, as long as they're giving you back that declaration, they're entitled to that transitional period protection. Again, AB 1482 that I mentioned earlier is expanded. There's limited exceptions under AB 1482 for evicting anyone. One is that they violate some non-rent provision. If you want to remove the property from the rental market, if they are engaged in a crime or there's a health hazard other than a COVID outbreak, those may be bases for coming in within the exception. Again, if you're outside Alameda County, if you're out in Alameda County, you're stuck with the Alameda County ordinance, and the local rules there reinforce that you really can't go in except for exceptions that are under the county ordinance. Next slide, please. Here is, thank you, beautiful, Carl, for putting this in here. Here is the new 15-day notice, notice to pay rent. And again, I'm talking maybe to landlords here that know what I'm talking about, but if you're not a landlord, historically, all you needed to do is give a 3-day notice to pay rent or quit. 3 days. If you haven't paid rent in 3 days, boom, we go to court. And it's the fastest procedure historically that the court allows, because historically, property rights predominate. If you own property, you should be able to reclaim possession of the property that you've leased out to somebody if they're not paying rent. Now it's 15 days, okay? And it tells you notice is given within 15 days, not including Saturdays, Sundays, or other judicial holidays. After service this notice, you're required to pay rent or complete and sign the attached declaration of COVID financial distress or move out, okay? And so then you go all the way back to September 1st and go through each of the months and the balance that is due. So notice that it doesn't say the rent due back in March, because again, that rent is not the basis for you to go in and force somebody to surrender or move out of the premises. And so then they identify that, and then there's a total rent due. Next slide, please. And then this continues on. And then this is a form that you should pick up. You can go to the state website, and you can find the forms there as well. And I will give you in the chat menu some websites at the end here. But there are the forms that you can pull down. If you're not a member as a landlord, I really encourage you to be a member of the California Apartment Association or some other group, because the California Apartment Association has their own forms. This continues on with the notice. Then if you do, then they can declare forfeiture of the lease, and they can pursue the landlord can pursue an unlawful detainer, an eviction process, if you do not submit the declaration or pay rent within the 15 days if you're not suffering from financial distress. It also goes through, the notice is here embedded, again, about the 25%, and it explains step by step to the tenant what they can do if they qualify. Next slide, please. This is kind of, okay, this is, if you can go back, this is kind of merged together at the bottom, instructions for declaration. The following is to be completed and delivered. This is where the landlord is telling the tenant how they can submit the declaration. And one of the things that I think is very practical is if you've developed an email correspondence with your tenant or vice versa, you can email these forms back. And so that there's no question that you delivered it. Next slide. This is the declaration that the tenant has to give. This has been in place since September. I have had a lot, this is under penalty of perjury. No documentation is required by the tenant unless they're a high income tenant. Loss of income caused by COVID, increased out-of-pocket expenses directly related to performing essential work during the COVID pandemic. Hard to prove how that would be the case, but if you can somehow say that truthfully, because I've been a health, first responder in the healthcare industry or firefighter, maybe you can truthfully say there's been some out-of-pocket expenses that you've had to incur. Directly related to health impacts. If you're uninsured as a tenant and suddenly have to pay enormous amounts of money for hospitalization or medication, that would be a basis. Child care responsibilities to care for an elderly, disabled, or sick family member that has limited your income. So you're only working part-time versus full-time. And then it goes through. And then also saying that the public assistance that you've gotten doesn't make up for it. Again, if you're not a high income earner, I'm going to get lots of questions say, well, can I ask to see their unemployment insurance check? The answer is no. Okay, the only penalty is if somehow you were able to prove they were lying. Some theoretical prosecutor would prosecute them for perjury. I doubt that the DA is going to have this as a high priority, but this is between landlords and tenants. The legislature has made the policy decision that we're going to try to keep. We're going to assume that tenants are trustworthy. We're not going to be upending their lives by having to prove things. They should be able to get a safe harbor if they have that they take seriously enough saying that this is true. Next slide, please. There's now two kinds of debt. There's the rental debt for failure to pay rent at all, or by failure to declare hardship in a timely manner. That's the old traditional non-payment rent. Or the 75% of the rent that you get to defer if you've timely applied for a declaration. If somebody has submitted a declaration and they only get 25% of the rent they pay, out of my example of the $3,000 out of the $12,000, what happens to the other $9,000 that wasn't collected before February 1st? That you have to go to small claims for, but you can't go now, okay? It'll be later in the year. And one of the things that they've changed is that historically, small claims recoveries against individuals is capped at $5,000, remains capped at $5,000 unless you're a landlord trying to recover rent. And so if you have a tenant that owes you $40,000 in back rent, eventually you'll be able to go to small claims and treat it like a consumer collection. Next slide, please. Before you go in and file an unlawful detainer complaint, you have to show that that you made good faith efforts at investigating rent relief, okay? And getting it rent relief, whether at the county or the statewide program. And I'm going to talk to you about these programs towards the end. Sought governmental third-party assistance. You're going to have to make these declarations to the court. Cooperated with the tenant in seeking relief. And that applies not only to the 75% in small claims, but or refusal to qualify for COVID-19 hardship financial distress. So you're going to get a situation that you've got the 25% from the tenant, but you're now trying to collect that other $9,000 out of the $12,000 that was owed to you. You're still going to have to show that you made efforts to have the tenant come up with some of the difference, so that it was not all on the tenant to have to pay that. You can file an unlawful detainer complaint outside of Alameda County for properties outside of Alameda County after June 30th, if the tenant fails to submit COVID declaration. But this is the little sneaky thing that may happen. You're going along saying, gee, this tenant has not paid. They've not given me a declaration of financial distress. They've blown me off. They paid zero rent, or they just paid me a couple $100 here, and I'm chasing them. Okay, I'm ready to go in, and I'm going to go in with my unlawful detainer. I should be able to sue them and serve them, and after 5 days, we'll go to trial. They file an answer, then we'll get a trial date. Everything's like it used to be before. I can kick them out, get a tenant that will really pay, and I need a tenant that's going to be responsible and pay rent. Well, they put something in there that really can be upset the balance of power between the landlord and tenant. The tenant can say, I got the notice, I saw it, I just didn't deal with it. Here's my declaration of hardship. And it's up to the judge at that point to say, okay, even though you didn't give it within 15 days, you really do have financial distress, and we're going to dismiss the unlawful detainer as long as you pay your 25% and you go. And so then you have to start all over again. So this will be very frustrating for landlords and tenants, and going forward, we'll see how this plays out in the summer. I would hope that the courts would provide, as some do, some mediation services like they do for small claims court, that there may be mediation services provided as free or as a service to the parties when they're in the courtroom, so that they can work out some payment plan and maybe defer a stipulated judgment for eviction at that point, because otherwise you're going to have, there's going to be a lot of time wasted having to start all over again. Next slide, please. There are now new tenant protections under SB 91 for the first time. Again, there are two classes of tenants: those that have submitted their CITRA, or now SB 91 hardship declaration of financial distress, and all residential tenants, including the ones that have submitted their hardship declarations. The tenant protections that apply specifically to CITRA SB 91 hardship declarations is that you cannot collect late fees, whether unpaid before or after to the declaration. So they may have 10 months of non-payment. You have something in your contract that allows you to a late fee of, however many, $50 per non-payment, or whatever that amount is. You cannot add that to the amount that's due, and it's just the base rent. And you cannot increase or charge new fees for services. And an example here would be, let's say you have a parking charge, and the CITRA SB 91 tenant has submitted a declaration. You cannot, on that tenant, even if theoretically you did it across the apartment complex, increase parking fees during this period of time. What they're trying to discourage, frankly, are landlords trying to collect rent through other means of non-rental expenses as some way of trying to, pad themselves from the fact that they weren't getting rent directly from the tenant. for all tenants now, whether they give you the Citra declaration or not. A lot of leases provide that at any time during the course of the lease, you can take the security deposit and apply it to non-payment of rent, even during the pendency of the lease, and then maybe you can ask them to refurbish or resubmit their security deposit, pay once more and fulfill their security deposit obligations. You cannot do that now without the express written permission of the tenant. Rent payment must be applied to future rent. I had this question early on and I guessed right before the law made this a requirement. Let's say you had a tenant that didn't pay in, let's go back to 2020 because that was a critical bridge period between the protected period that ended on August 30th and now the transition period that starts on September 1st. Let's say you had a tenant that didn't pay you July and August of 2020, and then they paid you in September of 2020. Well, the landlord wants to apply it to back rent. And especially now where you can never use that period of time to use as a basis for an eviction later on, you want to get them caught up, so to speak, through that protected period between March and August of last year. The law says you can't do that. You would have to apply it in real time to the month in question. So you'd have to apply that September rent to the September, even if it was more than the 25%. You could say, well, I only have to accept 25%. Can I use the other 75% to apply it to the back rent? No, it has to be in real time. And then that tenant in that theoretical example would have already built up a significant credit towards non-payment of rent in the future. They gave you a declaration at least of the 25% that's due throughout the period of the transition. You cannot assign a rental debt collection to a collection agency until July 1st, 2021. And you can never do that for tenants who qualify for rental assistance. So if some tenant has gotten rental assistance, they become a protected class. And for the non-payment of rent, you might be able to go to small claims on your own, but they're going to be forever protected by credit collection agencies that have more resources and more ability to enforce debts after judgment. Next slide, please. This is what people are here for, maybe. If you've got a tenant that's not paying, and that may qualify. There is money, but I think that the reality is that the reality that I hear on the street is that the demand is already exceeding the assistance levels that are out there. So you're going to have to at least show a good faith effort with the tenant. And if the tenant qualifies but doesn't get paid or doesn't qualify, remember that exercise itself is valuable for you in showing either filing eventually an unlawful detainer complaint or going to small claims for the portion of the rent, the 75%, up to 75% of the rent that wasn't paid under Citra or SB 91. Who qualifies? Household income of 80% or less of area median income. I had the chart here earlier that was given, but there's other charts that you can get for each county that only focused on 130% of median income. I'm sure the charts are available. What is 80% of area median income in each county? One person in household must either qualify for unemployment benefits or financial hardships due to COVID-19. One person in household is risk of homelessness or housing instability, past due utilities or rent or eviction notice, unsafe living conditions. All of those are factors that are part of the qualification. They're going to start sending out funds in 3 rounds at the statewide level. Less than 50% of area median income are going to be the ones that first are in line. It's kind of like the vaccines. The people that were over 65 were first in line for the COVID vaccines. People that will be first in line to get relief for assistance are those that are not only 80% or below, but 50% or below area median income. So if you have, working class tenants that have kind of managed to stick in there for working, they're probably never going to get down to 50% of AMI in this area if you've got tenants that are bringing in income. communities disproportionately COVID impacted. This to me is my political radar going up. What this does is our state legislature is dominated by legislators from LA Basin and Southern California. Where was the COVID impact greater? In LA. We were pretty good. We've been pretty good in the Bay Area. So we're never going to qualify in the second round of funding. We're going to be then, if you don't have a tenant below 50% AMI, then you have to wait for the third round of funding up to the remaining 80% as long as the funding is there. And that's become available as of March 15th. I'm going to go into the chat bar here, if you don't mind. I'm going to type it in, or you want to go to the state one. If the state one is applies, is www.housing.ca.gov. And if you go to that site, you'll see on the website there all of the statewide programs. Next slide, please. Again, landlord and tenant really should cooperate and apply for funds. The state funds have become available as of March 15th. Up to 80% of rent due. You can now go back to that protected period, at least as of April of last year, and try to collect. But this is the important 80-20 rule, okay? Not only is it 80% of AMI, but there's an 80-20 rule. And that what that means is that if the tenant gets rental assistance, and instead of $2,000 a month that you had for my hypothetical tenant that had to pay for 6 months up to $12,000, that $2,000 rent means that you have to forgive 20%. Well, 20% of $2,000 is $400. So your rent that you can collect is a maximum $1,600 from that tenant who qualifies per month. You have to waive it, and then they qualify all the way up through March 31st, 2021. What if the landlord refuses to apply? Says, I don't want to be participating in government assistance. I believe in the free market. I want to ignore all of the state funding. I expect my tenant to pay. Well, that's the wrong attitude, because the tenant can apply, and if they get assistance, they could have gotten maybe up to 80%, but all they have to pay you is the 25%, and you're out of luck. Okay, for the other 75%, you can't collect the other 75%. Can you refuse even the 25% from the tenant because it's not from their source of income, but it's from some third party or from governmental agency? No, because then you're running afoul of the fair housing discrimination laws, which prevent you from discriminating against tenants based upon the source of income that they rely upon for paying rent. You run the risk again of if you do not do these steps of trying to get assistance, that the small claims judge could eliminate or reduce what you can recover in small claims. This is also a question I get all the time. So a tenant leaves and I got a judgment, or a tenant leaves and they're gone. Can I go and get assistance and can I work with the tenant that left to try to get me the rental assistance that's due, past due, but they're gone? No, this only applies to tenants that are remaining in possession. And you're going to say, well, that's unfair. If there's all this money, can't I get some money for the tenant that left for whatever reason, and I'm still out? Why can't I get this money? This goes back to the beginning public policy objective of all of these moratorium laws. The focus is on trying to keep tenants in possession. And if you have limited funds, the legislature is making a choice between trying to incentivize tenants staying in place that want to stay in place versus not funding those that may have moved on for whatever reason. And so those are two different kinds of tenants. The tenants that want to remain in place, reduce COVID transmission. They're not out in the community trying to move and haul their materials, unvaccinated, coming into contact with other people. They're staying home, staying in place. And so again, the funding is trying to incentivize and soften the burden on both tenants and secondarily on landlords for tenants who remain in their residential properties. Next slide. This is a slide itself, which needs to be updated. I gave this seminar beginning in early March. Housing community development applications for rental assistance, that is available. But the way this works is very interesting. Fremont has got one, and I'm going to put if anybody has property in Fremont, it's called Keep Fremont Housed. So it's www.fremont.gov. Keep Fremont Housed. Okay. And, or just Google it. It should work. And I'm sorry, there's no .com on the end there. It was my mistake. You go to the Fremont site and you can go put Fremont Fremont Housed. And you'll come to a website there where Fremont has qualified for $7.1 million. What does that mean if you're a Fremont landlord? That means you cannot apply for statewide housing. You're limited to applying under the program that exists in Fremont. Similarly, if Santa Clara County or the city that you're in Santa Clara County or San Mateo or the city you're in, wherever you are, you're going to have to look at county or city sources first for rental assistance and check that out. And the tenant's going to check that out. There are a number of tenant advocacy organizations, which frankly, at this point, you should learn how to rely on them as well because of this cooperation requirement to identify the local sources of funding. First, they're more immediately available, but secondly, the way that this legislation's been set up is that the statewide assistance, as I understand it, only applies for tenants and landlords that do not otherwise have rental relief systems in place from local jurisdictions. Again, we'll see what happens with the passage of the American Recovery Program. I haven't studied that in great deal. That happened, and that did happen. And to see whether that helps with more funding at either the state or the local level.
Hey, Carl, can you mute the attendee? Sorry about it, David.
Sure. In fact, it wasn't the ARP, but the CDC has extended, the Center for Disease Control has extended its moratorium through June 30th of 2021. And that's kind of a wild card for me. I don't know if you're going to be posting the declaration that as the form. That's the 15-day for the protected period for March 1st, 2020 through August 31st, 2020 that I mentioned to you about under Citra. That's not the form, that's the state form. But let me go to the last bullet point first. Again, I'm reminded you that the governor has allowed for jurisdictions to have commercial moratoriums, deferral of rent payments through June 30th, 2021. So we'll have to see after June 30th whether that gets further extended. Anyways, the CDC has created its own declaration under penalty perjury that has some of the same overlapping claims made by a tenant as to why they have financial distress and cannot pay rent. And there is, in theory, the claim that the CDC moratorium does not apply where the state law is at least as protective or more protective for tenants than the federal law. Well, we get into a little bit of, it may be a so what, because remember I said that we can't evict for anybody that has claimed tenant relief under Citra or SB 91 until July 1st, okay, or there's basically a moratorium across the board. So it really doesn't have a practical effect as long as the moratorium doesn't extend further than the June 30th sunset on SB 91. Where it may come into play is that you have a tenant that never paid rent, never gave you the SB 91 declaration, but on the last day of June 30th gives you the 28th or 29th gives you that declaration. And does that excuse the rent for that period of time retroactively? How will the courts handle it? again, it may be a so what, because I said that there is this lurking provision, which I think should have been taken out of the legislation because it really disrupts the expectations of the party, where a tenant can come in based on a declaration of hardship at court and have a motion heard. So they could stack the deck by giving you one of these CDC declarations, ignoring the Citra and SB 91, and then maybe give you the SB 91 hardship declaration as a way of justifying why they didn't play by the rules and try to at least pay you 25%. So these are going to be issues that you're going to have to get an attorney to advise you on. I don't want to speculate because it hasn't played out yet. There's no court case that I can rely on that says, do you follow state law versus the federal law? I know there's been some attempts, and I don't know how far they've gotten when the CDC had extended eviction moratoriums nationally through the end of the last year, and then with the Biden administration extending it further. There have been some attempts in federal court to challenge the authority of the CDC to issue nationwide eviction moratoriums. So the more likely event is if for some reason the CDC, Center for Disease Control, has exceeded its authority and its mandate from Congress in its remedy of this national moratorium, that would more likely be a scenario that would happen than any determination quickly and usefully for attorneys and landlords to know as to how the CDC moratorium interplays with the SB 91 and Citra moratoriums. So at this point, I think this is time for Q&A.
Yeah, very good. Yeah, that's very, very informative. So we do have a couple of questions that the attendees have placed in the chat box. So let's start with the first question, David. So it's a question from Advocate. Say, Advocate asks, can a landlord raise utility bills such as water, garbage, or internet in Alameda County? And how does the tenant respond to this request?
Well, it's a very good question. Again, I think legitimately they can do so if it's substantiated, but they can't do it if it's shown later on that suddenly, in addition to non-payment of rent, the landlord tries to go in for claims for non-payment of utilities. Well, there's a two-part question. If sometimes, it's not in the question, but to answer it, I would have to look at the lease that this landlord has in Alameda County. Sometimes it is treated as rent. Utilities and other costs are just treated as part of the definition of rent. And again, that would have to be deferred as appropriate. If they didn't pay, they'd have 12 months to pay it. But yes, if the answer is, can you increase it? You can, but you can't use it as a backdoor for rent increases. And again, if you're in a jurisdiction, if it were treated as rent and it was somehow excessive, then it may be viewed by a judge later as a backdoor attempt to collect rent and increase rent. As long as it's a legitimate pass-through and you can demonstrate that the utility bills have gone up. Internet cost, internet access, Comcast is charging more for its rates. I would only do that if there was some substantial documentation that you could justify it later on, as opposed to trying to find other ways. The suspicion will be by tenants and tenant advocates and courts probably in protecting tenants that you're not using it as a backdoor to increase rents improperly. But the basic answer is yes.
Got it. So we have a question from Jay. Jay is asking, if the tenant refused to apply for rental assistance, what can the landlord do?
Well, I think the landlord needs to demonstrate that the tenant refused to apply for rental assistance. You can, for example, you can download applications that the landlord has to sign, and you would have to demonstrate to the judge, here, I gave it to the tenant and the tenant refused. And here's the signature on such and such a date. So before you get to the point of saying, well, the tenant told me that they're not going to apply, if you don't have any documentation, the tenant's going to come in and say, the landlord prevented me from getting rental assistance. You go, well, that's not true. Well, landlord, where's the record of you trying to get rental assistance. Well, Judge, I didn't have any because he told me not to, he was refusing to do it. So again, when you're getting into a situation where you're saying, what if the tenant does this? The way I view it is you got to view it how it will appear in court, because eventually you're going to go to court and some judge is going to look at what you did and what you didn't do. And the burden's really going to be on the landlord, as I mentioned earlier, to show that they made efforts to try to get rental assistance. If at the end of the day, the tenant refuses to do so after your good faith effort, and assuming that the tenant is not otherwise independently qualified for 25% rent per month under a financial distress or financial hardship declaration, then you can go in under a traditional unlawful detainer and try to collect the back rent for non-payment of rent. But you gotta be careful, okay? And remember that if they, so document, okay?
Yeah, I think in your previous seminars, you have indicated that the landlord might not be able to get evidence of, say, financial document to show that they are, say, unemployed or laid off. So when you mentioned earlier that, to show the financial distress, so what would be the best approach? If does the law allow that the tenant have to provide some documents that they do not have the income or being impacted by pandemic to pay rent?
There are two kinds of tenants. The ordinary tenant that is not a high income tenant, all you have as documentation is his signature or the tenant's signature or penalty of perjury. That's supposed to be sacred enough by saying that it's under penalty of perjury with the risk of prosecution for lying, that's your evidence. Okay, if it's a high income earner, which is 130% of area median income, and you have some reason to believe that they're a high income earner, it's a little unclear in the law how you know that. So I give the example, if you happen to know that tenants work for Google or somewhere else where you expect that they're engineers by profession, that they're earning six figures, then you can demand W-2s and pay stubs and other documentation that in the form for, there is a separate form I didn't show you for hardship based on high income. It says right there that the tenant's mere declaration as a high income earner that they can't pay rent is not enough, and then you can and they must provide documentation to prove it, that they've lost income.
I see. So like say before the landlord do that, probably might be best to consult a attorney or legal professional before they proceed, huh? Just not making sure that they're not walking the line.
Yeah, if they're doing this blind and just thinking the old rules apply, let me give you a hypothetical. It's not on the PowerPoint, but it may be of interest to your clients and certainly to you, Monica, when you're listing property.
Yes.
I have a buyer that wants to buy this beautiful home in Danville, and I've been advising him for the last couple of weeks. The multiple listing service said that there was a tenant that lived there. Okay. Oh my gosh. The owner is not owner occupied, it's tenant occupied. And apparently verbally, the owner told the broker for the buyer, hey, the tenant will be out, no problem. Well, now I got a situation that the tenant wasn't out, escrow's coming out, got a landlord, the owner is trying to shift the burden to the buyer and saying, well, I can't get him out because of the moratorium. Well, that's always true. So if you have a tenant occupied property and you're trying to sell it, and if you're a buyer, you got to be really careful, and they really have to show you some agreement where the tenant's voluntarily agreeing to terminate a lease early. In this instance, what we got was, the tenant will be out, and only months after escrow opened, and they didn't fill out the seller questionnaire. Honestly, they lied. There's a request. There's a question on the seller questionnaire whether there's any leases that will affect the use or title of the property. The seller marked no. Well, there's a written lease that turns out that it goes all the way to June 30th. And then he sent out a 60-day notice of non-renewal. So he had lied to the buyers about the existence of the lease, and then he shows them the 60-day notice of non-renewal. Well, remember earlier I talked about AB 1482? You can't, as a landlord, I think this is a question that somebody's asking, maybe you'll answer it here. You can't just simply say it's for a fixed term lease under AB 1482. Okay, your lease is done. you're out in 60 days. That used to be the case, but if AB 1482 applies, and it does during the moratorium to virtually any housing, you have to come up with a just cause eviction and do the notice the right way, which says we're removing the property from the rental market. And if you don't send out a notice that looks like that and provide relocation assistance, which is equal to 1 month's rent, either forgiveness or payment of 1 month's rent, then you as the landlord don't even have the ability at that point to go into court if he hasn't left at the end of the lease, because the tenant now under AB 1482 has the right to demand an extension of the lease under the same terms. So there's no such thing anymore under AB 1482 as a landlord fixed term lease. It's a lease that will never end as long as the tenant wants to stay there and pays rent. So there's all of these interplays now between the new laws and when you're trying to buy and sell property. So if you have that beautiful homes that you were showing us in San Mateo and Santa Clara County, you know, the first thing the buyer's going to want to know, and the first thing you're going to want to know before you're listing it, is it better not have any tenants there. The idea arguably is to, you know, hopefully go through that process first. It's even if you keep it off the market, or very, 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 you know, I don't recommend cash for keys, because there may be those things that worked in the past. The tenant may say, look, I didn't know about, you never give me these informational notices under Citra or SB 91. I don't know about these new laws. Had I known about them and I only had to pay you 25%, I would never have left. You pressured me out of here. You kicked me out. And then you're, as the owner, as the landlord, you can be subject to tort remedies for wrongful eviction. So that it is a minefield. So you have hot properties here that are tenant occupied. It's like this, you know, golden goose that's laid the golden egg. You want to grab that egg, but if you grab it too fast and kind of ignore the tenant or try to work around the tenant, you're stuck.
Got it. So in the past, we were under the impression that AB 1482 will not apply to single home, condo, and townhome for the just cause eviction. So right now, like because of the pandemic, the AB 1482 also apply to single home, condo, and townhome?
It may. I don't want to be completely definitive. I do know that I think it's the same product types. That for single family homes older than 15 years, my understanding AB 1482 did apply. So the only exceptions there were it was less than 15 years old, which means that there's a formal document that the city issues when they're ready after the past final inspection. There's something called a certificate of occupancy that's given to the new owner that says now you can move in. It's past life safety inspections. Now the owner has the right to move in. Before the city issues on a new home this certificate of occupancy, nobody can move in. So when you're looking at 15 years, and it's a rotating 15 years. So when the legislation passed in 2020, any house built before 2005 was within 15 years. It's for 2021 now, it's 2006. So as the years go by, the 15 years you have to measure back from the current year. So my understanding is AB 1482 did apply to single family homes. The reason why you mentioned those often are exempted is that that you have mom and pop owners. And so you can exempt yourself because the ownership is such that they're not corporate owners. So to the extent that they applied before, and I got to check that, Monica, I don't want to be 100% guarantee on my response here. To the extent that AB 1482 applied in those situations before the pandemic, that now my understanding is it applies to anybody that's not that is not a corporate owner currently.
I see. Okay, I really appreciate the clarification. So I have a question from Yuhai. I think it's quite similar to Jay's question, but then the case is like the tenant didn't pay rent and didn't return the hardship declaration, but they just left the rental properly. And how should Yuhai try to recover the rent, and can he apply for the state landlord assistance program? And if so, how to apply with the tenant being moved already?
Okay, there's a couple of questions there. Let me try to break it down this way. The state relief program, in theory, is independent from SB 91. So in theory, if somebody qualifies for assistance, there's no requirement that they've submitted a declaration of hardship to qualify under CITRA, to my knowledge. They simply submit the application if they qualify. Why they wouldn't apply for CITRA is a very interesting question. I mean, that's just not a requirement. So in theory, you could get somebody that does the financial assistance. And at that point, if they do and you accept it, then you've already reduced your rent by 20%. And if you don't and refuse to reduce your rent, then they can pay just 25% of the rent under the financial assistance, and you're stuck with that. So and again, they're not going to differentiate when you go in whether somebody gave you a financial declaration or not. When you go in with an unlawful detainer complaint, you're going to have to show good faith efforts across the board. So you may very well have tenants that have not paid you rent, not giving you a declaration. You're still going to have to reach out to them and say, you haven't paid rent. Here's a form. If you believe, here I filled it out. It's a statewide form. You believe you qualify, submit it, or to the local agency, whatever it is that is in place for the funding. And if they ignore you then, and you need to show that documentation, you've proven that you've done a good faith effort to try to provide them tenant relief. And then eventually on July 1st, you've given them the 15-day notice to pay rent or quit. They didn't give you the hardship. You can go in and do a traditional unlawful detainer, include all the past rent that's due. But again, keep in mind, I'm going to repeat this over and over again. You could be a very frustrated landlord that suddenly gets an SB 91 declaration of hardship at court to the judge saying, I've just been under stress. I've been emotionally not focused on anything because of the pandemic. I didn't follow any of the rules, but here's my declaration of hardship, judge. And I really have been out of work and I really can't leave the house. I've got 2 kids. I've got school next year for these kids and I want them to go back to school at the neighborhood school. I'm now trying to get my act together, but I really couldn't pay rent. The judge believes the tenant, you have to start all over again.
Oh my. But like say in his case, the tenant already left the rental property. Would that be a way to recover any rent? I think you mentioned briefly on your presentation.
Oh, okay. I'm sorry. If the tenant, that was another part of the question. If the tenant's already left,
yeah, they left.
That changes everything. It's no longer then, assuming that you got I would, again, if the tenant chooses to leave, I would want documentation from the tenant that they've voluntarily agreed to terminate the lease early or just simply terminate it, and that they've returned the keys. Not cash for keys, not something where you're inducing them to leave early, but if they voluntarily leave, you want documentation that you didn't kick them out. So that protects you from further liability down the line. The tenant leaves, they've got back rent. I covered this in one of my slide bullet points earlier, but I'm happy to emphasize it. You cannot go obtain the tenant, neither the tenant nor the owner can go and obtain relief assistance for the past rent. You can't apply. The legislature has very limited resources financially. They're only focused on tenants that continue to remain in possession that may qualify. For past rent that was not paid, if they never gave you a declaration of hardship, or even if it becomes basically a breach of contract action, you sue them for breach of contract for non-payment of rent. And it's no longer tied to possession, so it's a contract action. If the most rent agreements have an attorney's fees provision, you go after that tenant and then sue in regular court. And it's a regular trial. You do not get any accelerated timetable for hearings or trials because you're no longer trying to recover possession, so you don't get the benefit of the unlawful detainer expedited process. You might have a trial a year or 2 from now if you get a hold of them.
Yes, I think going back to your Daniel scenario that you're helping the buyer on the case, like say, trying to face the seller. So both Viren and Jay have the same question. Has the rule changed for selling the house and giving 60-day notice? Like Jay also have the same question. 60-day notice to the tenant and being the reason is to sell the rental property. I presume that like those are single home.
Yes,
Because
the
like
rules
maybe
have
multiple
not-
unit is different. Yeah.
the rules have changed in this respect, that if AB 1482 applies, you need to have a notice that says this is a just cause eviction. The just cause eviction is that you're removing the property from the rental market, okay? You have to specify that in your 60-day notice. You can't just simply give out a 60-day notice like in the good olden days, okay? If AB 1482 applies, and my understanding, although I need to research this, you need to get an attorney to give you formal legal advice on this to confirm this, but that if AB 1482 does apply to your single family home, if you don't give a just cause notice, if you simply did what this seller is doing in Danville, which is wrong, which is simply saying your lease is expiring and I'm giving you a notice, a 60-day notice of non-renewal, that's not going to work. So you have to do it right. And then, we're already past April, so the 60-day notice is going to carry you, my math is correct, into, well, it's April, May, June. Right now, you'd still have to wait until June 30th because of the moratoriums to go into court. Okay, so 60 days ends up being 75 days if you're to give one right now.
So in your Danville case, are you trying to help the buyers to get out of the contract, being that the seller did not have the right disclosure?
Well, in this case, what I'm doing is hopefully getting a new addendum where there was another promise made by the seller that the tenant was going to voluntarily leave a month early on May 31st. So we're going to extend the escrow date and hope that the the seller's tenant vacates. For agents out there, this is advice for agents and certainly for sellers. In a standard residential purchase agreement from the California Association of Realtors, on page 3 of 4, paragraph 9D, it's actually bolded, but it's small print. The seller has the obligation to vacate the property for tenant occupied property, and the default is 5 days or otherwise as agreed to, 5 days before escrow is to close. Failure to do so is a breach by the owner. So this owner who doesn't have a real estate agent advising him, he only got the agent to list the property on the multiple listing service, doesn't have a seller. The property's for $2 million, and the guy is he's exposing himself to huge risks by trying to do it on the cheap. You should hire Monica. If Monica was his listing agent,
yeah, thank you. Be happy to. Yeah, well,
we would have a smooth sailing. But what ends up happening is that the seller thinks he knows too much. He thinks he's brighter than everybody. He says, well, the buyer has a no contingency offer, so since it's no contingency, I can do no wrong. Well, no, the contingencies might apply to whether the buyer got a loan or not, whether the appraisal value comes in, whether the disclosures are satisfactory or not. That's on the buyer's end, but that paragraph 9D applies to you, seller, whether there's a no contingency deal or not. It doesn't waive 9D. So it's extremely important to see that. And so, eventually, then this gets into other things. The seller not only may be able to be required to refund the escrow, but there may be other damages beyond that, liquidated damages, which go beyond breach of contract or fraud. My guys would never have entered into the deal. I would have, if I had been the broker and the attorney on the inception, you never want to rely on verbal promises. But once he kept saying that, and then he lied on the seller property questionnaire that there was nothing affecting the lease, then he can begin relying on that. And so that's an issue that I think the buyer has a good claim for fraud, in addition to breach of contract. But we're trying to work it out. The buyer wants the house. And if the seller signs an addendum, extend the escrow beyond the date that the buyer, the tenant is supposed to be moving out voluntarily.
Moving out.
And I'm also saying, one of the things, I want to make this general, not just about this case, but this is important too. If you have a tenant occupied property, I think as the buyer, you're going to want to build into the an addendum right off the bat, maintain that the seller has the obligation to vacate the tenant occupied property, but that the seller has an obligation to document that the tenant has signed a document voluntarily terminating his interest in the lease. You don't want to have a tenant saying, gee, I was cash for keys. I'm going to sue the seller and the buyer. They conspired to kick me out of my house. I didn't know I had all these rights to stay there forever. So if you have the time, and again, it's frustrating if you're looking at these beautiful homes and you're a highly motivated seller, the best is to have the tenant gone out of the property before you try to list and sell it.
Yeah, it certainly makes sense. Yeah, I totally agree. So I do have a few more questions. We try to catch your time because I know that we have like 10 more minutes before the due time. So Xiangming Shen have a question. They say, if the tenant does not provide income, even though they have the group of the high income earner, how would the landlord do?
Well, if it's a high income earner and the high income earner does not fulfill his obligation to document that he is a high income earner, then the declaration of hardship is invalid. And you can go into court and sue for, after the 15 days notice and after the moratorium is lifted on June 30th, on July 1st, you can go into court and sue for past rent.
Yeah, so they have to bring it to court and kind of sort it out between the owner as well as the versus the tenant, huh? But it would be at the end of June 30th. Got it.
Right, but if you think it's a high income earner and you've given a 15-day notice to pay rent or quit, and there's a declaration submitted by the high income earner saying I'm a high income earner, yeah, but I refuse to give you any documentation. You need to document that before you go into court, saying you got to provide this documentation to me. If you don't, I'm not going to. I asked the landlord, I'm not going to honor this declaration of hardship, and have that documentation already, because if you get into court and you're arguing about verbal conversations, then the tie is going to go to the tenant, because the tenant's going to say something differently than what you remember him saying. I'm not saying people are lying. People have different recollections, and the tenant's trying to stay where they're staying. The tie is going to go to the tenant. This is something that I think I forgot. I should mention this to this particular group. I see a number of people that presumably speak Mandarin Chinese. If you have negotiated, this is true across the board, and this applies now with all of these forms. If you have negotiated a lease with a tenant in Mandarin Chinese, or if you're Korean or speak Korean with a Korean tenant, or Tagalog or Spanish, it applies to other languages, you must, with specified languages, and Mandarin Chinese is certainly one of them, provide forms to them in Mandarin Chinese. The leases theoretically should be in Mandarin Chinese as well, if you negotiated primarily in that language. Obviously, if you're speak Mandarin Chinese, but you have a non-Mandarin speaking tenant that speaks English with you and you're negotiating English, it doesn't apply. But if you have developed a niche marketing of tenancies with people that also speak your language, if it's Mandarin, Korean, Tagalog, Spanish, there is a few others, if you fail to deliver these forms, and they are available in the language that you negotiated in, that's another basis for invalidating the form. So you can get back a declaration of hardship, or you can send out an informational notice in English and get nothing back. The tenant who speaks Chinese says, well, I was negotiating Chinese. I didn't know what this was. I didn't understand it. That's why I didn't respond to it. That's a whole other area that you need to be familiar with.
I see. Yeah, thank you for pointing it out. So Xiaoming have a continued question. Say, what if this tenant does not belong to the high income, but the low income group, the regular working class?
What's the question?
Yeah, because the question is, like, say, if the tenant do not provide any income, even though they have, that's what the landlord think they have.
Okay.
So like you said, there are two categories. So if, when they apply for the house, it does not show like high income group, maybe working class group.
Right. If they're not high income and they give you a declaration, there's really two classes. High income earners have to provide you a declaration of hardship with documentation. Everybody else that's not a high income earner gives you the one page, and that's all you get as the landlord. But keep in mind, if they're not paying rent, you're now going to have to go through the exercise of trying to assist them in getting work with them and trying to get financial assistance. And they're going to have to provide more documentation to the state or the county or local authorities at that point to get the financial assistance. So if they do get financial assistance, that would be more, more proof that they were telling you the truth. And the benefit to you, although in the short term it doesn't sound like a benefit, is you get 80, maybe up to 80% of your rent if they qualify, and have rent sufficient to pay up to 80% of the rent that's due. Okay.
Got it.
So look at it. Look at
very.
Let me rephrase it this way. Again, because I'm an attorney, I think about, okay, I've got a client that's filing an unlawful detainer complaint. You got to assume, what do you have? What's the worst case scenario that's likely to happen if you have a tenant that's intransigent and not paying rent? You're going to be in court. What are the steps that you're going to need to do to maximize your chances of winning in court? And then you look backwards. So you're thinking, well, what if I'm frustrated. The tenant's not providing documentation. I want something. But keep in mind, if in court, before you file the unlawful detainer complaint, or as you're filing, you got to prove that you cooperated with the tenant in getting rental relief. You did all these other things. It's not just about you and the tenant anymore. You got to look at how the judge is going to look at it, how the court, with these new rules that I've given to you and this PowerPoint that you can keep, are going to require you to go far beyond that. And the win-win for you is potentially, well, the win-win is, there's two win-wins. One is, if you cooperate, they cooperate, and they qualify, you get 80% of your rent, and you're not running around going to small claims court, which is going to be a nightmare. You want to avoid that, because all you get there is a judgment, and then you're going to then maybe turn it over to a judgment collector and get 10 cents on the dollar. You're getting rent in real time at 80%. That's a win. If they refuse to cooperate, if they don't qualify, you've preserved your right. If they don't do any of to collect back rent or collect your 75% in small claims, if they're giving you the declaration of hardship and no other documentation, if they're not a high income earner, but you need to preserve as many of your rights as possible by playing by the rules.
Yeah. The key is to play by the rule. Okay, so a few more questions. Like I summarized, Cynthia has two questions. One of it, I think you have also already provided very elaborated reply, about like a reason for removal of the tenant is because they want to remove the property from the rental market, but then that's a newer property built in 2018. And so for AB 1482, you mentioned that it's a 15 years of age of the property. Are they actually exempted from the just cause? And also for the, yeah.
You know what we should do? We should do an AB 1482 seminar all over again. So
exactly. So we should try to elaborate on that.
Because, and then what I could do is AB 1482 and then say how that's been impacted by SB 91, et cetera.
By the pandemic.
And then I can do it in a more systematic way, and I can be completely up to speed and answering it more definitively. Okay?
Yeah, because definitely, about the rent increase, again, you can answer this maybe in your next event that we're going to co-host together on 1482.
Right. And
yeah,
we talk about
that's a very, very good suggestion.
The impact of local jurisdictions on AB 1482, all of that. That's a whole different focus.
Yeah.
So I don't want to get too far down the line because I've been so focused on SB 91 and did mention as a bullet point its impact on AB 1482, but I'm being candid. I haven't fully vetted that issue and taken into account all hypotheticals. So I'm a little bit trepidatious about venturing in that area right now.
Yeah, certainly understand. Yeah, I appreciate very much for helping as as a community to understand the AB 1482 and the pandemic impact. So I have like 2 more questions. So far, I think from the attendee user, and he's asking whether you represent homeowners against HOA.
I have. I've represented HOAs as well. I do it on both ends, but the answer is yes, I can under the right circumstances. Oftentimes, the answer is yes. I don't want to qualify that. Certainly you're welcome to call me and we can find out more details. I don't want to hear it over the broadcast here.
Yeah. Okay. Yes. Good. The last question, I think, it's almost time, and you can either answer this today, or maybe if you want to leave it for our next event about the AB 1482, because this is from Advocate again. Can you provide further clarification if the contract and payments are rent and not including utility? And utility is not discussed that utilities are shared by other tenants along with the use of water. Say if it is an apartment building, then you have water to be shared, and also landscaping or cleaning shared by other tenants as this. Can this be an approved utility rate? And if the tenant has raised rent plus utilities since the beginning of the lease, is this different from the rent with the utility? Do you want to answer now, or maybe wait till we can explore a bit more about the 1482 to be discussed?
I'll do a little bit of both. I'd like to refer these kind of questions to an AB 1482 presentation. But one of the open questions, and again, one of the unfortunate things about the pandemic is that the courts basically really slowed down in terms of the processing of cases. So we don't have interpretation. But the rent caps are measured by what is considered rent. And it's not necessarily just the base rent, but I'll have to look again at what is defined as rent that is subject to the caps and what isn't. What you're describing to me are like common operating, almost like a triple net lease for a commercial tenant where you have shared pro rata expenses across the subdivision or across the complex. That probably isn't rent, but I don't want to speak definitively on that. Okay.
Got it. Yeah. So we can further elaborate, our next event. And one last question, I think we're going to wrap it up after that. It's from Kelly. Do you also have clients with the boundary, the property line, dispute cases?
Yes, I do. I actually have a very fun case right now where this happens still. It's rare in our urban Bay Area, but I have a property in the East Bay where the owner is selling off half his property, but because they did have a lot line between the two properties that were conjoined, but over the years since they owned both parcels, they put a carport that covered both ends of the property. So then you now have to do a lot line adjustment, and the buyer has to cooperate in getting from the city the documents to redo the lot line so that the carport remains on the property that my client's going to continue to live in versus the property sold. So that's kind of a fun thing. Buyer wants the property, seller is motivated to sell, everybody's motivated. But the reason it came to me kind of on an urgency situation, I got to work on it this week, is you got an escrow that's closing. And so we want to make sure that the buyer in that instance doesn't blow off the seller and then tries to sue for an encroachment or trespass of the carport on his property. So, well, you told me about it, but I don't have the full benefit and use of my property. So we got to adjust the lot line around the carport so that everybody's happy. So yes, the answer is yes, but that's a real life example of something I'm working on right now, which I think is kind of fun.
Yeah, wow. Interesting. That's good. So you're having both the sellers and the buyers. So really, really appreciate all the information. Have you taken cases on tree roots damaging to my pools and concrete slabs? Okay, this is, I think, probably also this is the last one. So it just came up. The last question is, if neighbor's tree, the root damages the pool and the concrete slab. So will you handle a case like this? Or have
I
you done
can.
this, something
Yes,
like
I
that?
can. Yes, it's called a nuisance, or it's a form of a trespass. And if the damages are high enough, absolutely. If it's a $5,000 to $10,000 case, it's not probably in your economic interest to hire me. But if you're talking about 30, 40, $50,000 to fix, that's fine. You know, whatever. Usually what I get are these calls, can you send a letter? And then the letter doesn't work, and then maybe it's a small claims action. So I don't want to discourage you from calling me, but the economics of hiring a lawyer must be proportional to the claim that you're making, because I want to solve problems. I don't want to be simply just taking money for its own sake. I really want to solve people's problems. And there's not a basis, to my knowledge, in these kind of disputes for demanding or recovering attorney's fees on the other side. So you have to make an economic decision, and I want to be realistic with all my clients as to what their expectations may be. But if it sounds like it could be pretty significant damage, and they should step up. You know, neighbors should
Yeah,
step up.
that's
and take
very,
care of it.
very well said. So like say for those who are interested to learn more about what Mr. David Bonaccorsi can do for you and handling cases and your problems, please reach out to David. And we're going to email to everyone today's presentation recording, as well as, of course, David's contact. And also the forms that David is kind enough to send to us, it will go out, like, say, on Monday to everybody who have registered for this event. And so for our next event, we're going to publish an email to everybody. Thank you, Alice. And I really appreciate, David, for your precious time today on a Saturday, and everybody attending. And then, well, we hope you all view and enjoy a very good rest of the weekend. Thank you.
Thank you so much. What a great privilege.
Yeah.
Thank you very much.
Thank you, David. Yeah, we'll be in touch about the next event on the 1482. Thank you.
Wonderful.
Bye-bye. Yes, thanks so much.